Everyone, welcome back to a new post today. It's 2025, a new year, and let's begin with our polity and governance for the week once again. So let's discuss the polity and governance for the week gone by from January 12th to January 18th. Many important news, polity and governance issues made headlines this week. Supreme Court highlighting that access to sanitation is a part of right to dignity. The denotified tribes expressing their anger and anguish over this implementation of the seed program. Prime Minister Narendra Modi addressing the youth on the National Youth Day and telling them that they were the front runners for achieving a Viksit Bharat by 2047 and few more of them. Let's go into detail by one into these issues, and let's prepare ourselves for the upcoming UPSC Civil Services Mains examination. So the very first is about the denotified tribes' anger over the seed program. So what exactly is the seed program? Now the seed program was launched by it's called Scheme for Economic Empowerment of the Denotified Tribes. It was launched in 2022 by the Ministry of Social Justice and Empowerment, and it aims to improve the social and economic status of the denotified tribes. The program includes scholarship, hostel facilities, and other support as well. The denotified tribes are communities that were considered born criminals during the British rule, and the Indian government repealed the Criminal Tribes Act of 1952, and communities were then referred to as the denotified tribes. They are considered vulnerable and deprived. The Indian government repealed the Criminal Tribes Act, and now they are referred to as denotified tribes, as I told you. Some examples are Koli, Ramoshi, Bazigar, the Bavaria, Bauria, Banjara, Nat, Harni. The National Commission, we have another body called as the National Commission for Denotified Nomadic and Semi-Nomadic Tribes, was established by the Government of India. It's not a constitutional body. The Commission's mandate to identify and prepare a state-wise list of denotified tribes for their empowerment. The Commission also evaluates the inclusion of denotified tribes into SC, ST, OBC habitats where they are densely populated. For example, in Tamil Nadu, some of the denotified tribes are the Ambalakarkar, Piramalai, Kalars, Boyas, Vayalars, Kaladis, Odars, and the Totia Naikars. So these are some of the examples every state has then. In Telangana, we have the Siddula, Domara, we had the Vadera, Dasari, and also the Veera Mushti, Mandula, the Katip Kapla tribes, the denotified tribes. What are the challenges that these denotified tribes face? They face stigma, exploitation from law enforcement and society, and they are often denied the caste certificates, which prevents them from accessing government benefits. So what is their anger about? First of all, they are denied caste certificates in many states, which prevents them from accessing many government benefits. The seed program has been very slow for taking off of the denotified tribes. The Idarte Commission of 2017 had recommended for a permanent commission for the denotified tribes, and also caste census and proper classification has not been implemented for these tribes. So this is the first issue. Let's go to the next one. National Youth Day, Viksit Bharat Young Leaders Dialogue was conducted. Apart from that, we also have Young Leaders Parliamentary Dialogue, which is conducted to bring awareness among the youth regarding the Parliament of India. So the Department of Youth Affairs, which is a dedicated department for the empowerment and policy making for youth, organized the Viksit Bharat Young Leaders Dialogue and on the National Youth Festival in 2025, conducted from Jan 10th and to Jan 12, 2025 at Bharat Mandapam. Prime Minister engaged with 3,000 dynamic young leaders from across the India. According to 2011 census, the youth population of India, that is from 15 to 35 years of age, stands at 333 million, which is 27.5% of the total population. The total population of India stood at 1.21. We are still balanced to conduct the next census. We had to do it in 2021, which was a digital census, first digital census. It never took off because of the COVID-19, and I think the next census will happen only in 2031. So definitely the youth population must have increased by now. And National Youth Day is also celebrated encouraging the participation of youth and recognizing the potential of the youth of the country on January 12th. And it is also called as Vivekananda Jayanti, being the birthday of the Hindu monk Swami Vivekananda. And in 1984, Government of India had declared this day as the National Youth Day. And since 1985, 2025. The event is celebrated in India every year. And the next issue is about the debate of linking the voter ID with the Aadhaar card, which still now hasn't happened and hasn't taken off. But linking of the Aadhaar with the voter ID is voluntary, but after a recent petition in the Supreme Court highlighting the forms of registering electors do not make this choice clear. So it is unclear whether it is voluntary or mandatory. The Election Commission of India has thus approached the Union government proposing amendments to the Representation of People's Act 1950 and voter enrollment forms to delete the provision that compels a voter to provide reasons for a decision not to seed the Aadhaar number with a voter ID card. And the proposal, however, is learned to have taken turned down by the Law Ministry. So when did this idea of seeding the Aadhaar with the voter IDs come up? It came up in 2015. The then Chief Election Commissioner H.S. Brahma had announced that the EC would start a drive to link the Aadhaar with the electoral roll database from March that year in 2015. The aim was to actually remove the bogus and the duplicate entries from the electoral roll, and it was to be completed by August that year. The Supreme Court, however, ruled that Aadhaar could be in 2015 ruled that the Aadhaar could be used only for government schemes, that is distribution of food grains, LPG, kerosene, and the EC stopped its drive. By then it had already collected 38 crore Aadhaar details. Again in 2019, the EC proposed linking of Aadhaar with the electoral roll for transparency in identification of the voters or the electors, asking the government to amend the election laws to enable collecting of Aadhaar details along with the voter ID and linking them or seeding them. The government then brought about the Election Laws Amendment Bill 2021, which was passed in the Parliament in December 2021 to enable the linking of Aadhaar and voter IDs. And under the Act, the EC restarted the collection of the Aadhaar, which was from July 2022 on a voluntary basis. A new Form 60B was introduced for the existing electors to give their Aadhaar number, and the form for new registrations was amended as well. So this is the reason is for transparency and to root out or to remove the bogus voter IDs from them, and also to ensure whether the Indian citizens are having the voters ID or not, or are they taken up by the neighboring immigrants who come into India. The next is about the Ombudsman of India celebrating 10 years, and recently the first Foundation Day was organized on 16th January at the Manekshaw Center, New Delhi, and it was inaugurated by Chief Justice of India Sanjeev Khanna. On this day, the Lokpal was established by coming into force of Section 3 of the Lokpal and the Lokayuktas Act of 2013. Justice A.M. Kanvilkar has been administered the oath of office as the second chairperson of the Lokpal in March 2024. Now, currently the body consists of a chairperson and 6 members as of March 2024. So how did this body come about? India ratified the United Nations Convention Against Corruption by depositing the ratification in 2011. The convention asks the members the obligation and makes some mandatory recommendations like dealing with criminalization and bringing about a law to deal with corruption, especially bribery in the government. And the Lokpal then was established in 2019 by appointing the chairman through the Lokpal and the Lokayuktas Act of 2013. The Lokpal has the jurisdiction to inquire into allegations of corruption against anybody who has or has been a Prime Minister of India or a Minister of the Union Government or an MP as well as the government officials, and the Lokayukta deals with the state level. So a complaint under the Lokpal Act should be in prescribed form, and it should pertain to an offence under the Prevention of Corruption Act of 1988 against a public servant, and there is no restriction of who exactly can make such a complaint. Now, the history of the Lokpal can be traced back to the early 60s. However, the body was recommended by the Administration Reforms Commission as well. And in 1963, it was Dr. L.M. Singhvi who participated on the discussions on demands of grants in the parliament and stressed that there is a need to set up a pattern of an ombudsman to tackle corruption and also redressal of public grievances. The term Lokpal and Lokayukta were mentioned during those discussions. Etymologically, the term Lokpal means protector of the people, and the term was coined as an Indian variant of the concept of ombudsman, which is used in the Scandinavian origin and also refers to an official who is appointed to investigate complaints of citizens against the administration or the government. So this is about the Lokpal, and Lokpal celebrating its foundation day on January 16th, the day it came into force in 2014. And Patna High Court judge now has been elevated to Supreme Court judge, therefore bringing the strength of the Supreme Court near to 33, which is the sanctioned strength. So the Union government notified the appointment of Krishnan Vinod Chandran. Article Part 5 of the Constitution deals with judiciary of this Supreme Court, and Article 124 mentions the appointment of the judges by the President of India. The collegium system is not constitutional. It has been come out over the three judges case, and it is a Supreme Court mechanism. So the appointment of Justice Chandran with this Supreme Court now will function at the highest strength of 33 judges against a sanctioned post of 34. The Supreme Court Judge Rishikesh Roy is slated to retire in January 37th. So the recommendation of the collegium headed by the Chief Justice of India, Sanjeev Khanna, had recommended the name of Krishna Vinod Chandran, the Chief Justice of Patna High Court. And presently the Supreme Court bench has no representation of High Courts from Jharkhand, Jammu and Kashmir, Ladakh, Meghalaya, Orissa, Sikkim and Tripura. Usually the Supreme Court ensures that all the states and union territories are represented on the bench of the Supreme Court or in the strength of the Supreme Court. Now the Supreme Court of India is an apex judicial body in the Constitution of India. We have an independent and integrated judiciary. We do not have a separate system of courts for the centre and the states. Article 124 of the Constitution says that there shall be a Supreme Court of India. The Supreme Court of India came into existence in 26 January 1950, taking over the Federal Court of India and the British Privy Council, and it functioned from the old Parliament building and until it moved into its newly located building at Tilak Marg in New Delhi in 1958. It was attended, and the first Chief Justice of India is Harilal Kanya. The Supreme Court, as I told you, came into force on January 28, 1950, replacing the Federal Court of India and the Privy Council. So this is about the Supreme Court having a new judge and coming to the strength. The initial strength when it was formed was 8, that is 1 Chief Justice Harilal Kanya and 7 judges of the Supreme Court. And easy access to toilets is an essential form for human dignity. It's a groundbreaking verdict by the Supreme Court, especially for the people with disabilities and the transgender community. So the court opined that toilets, washrooms, restrooms are just not mere matters of convenience, but a basic necessity and a facet of human rights. Access to proper sanitation is recognized as a fundamental right under Article 21 of the Constitution, which guarantees right to life and liberty, therefore expanding the definition of right to life and liberty in the fundamental rights of the Constitution. The Supreme Court has mandated the states and the High Courts to construct separate toilets for the males, females, transgenders and persons with disabilities. The Supreme Court issued categorical directions to provide separate toilets for transgender persons, thereby bringing about a landmark move 10 years after the pivotal judgment which recognized the transgender community as a legal community and a third gender as well. So the Nalsa judgment granted legal recognition to the transgender community, and this was a breakthrough judgment. The next is about frontier Nagaland territory to get autonomy, and this is now a new solution coming up for the demand for a separate Naga state. And the Eastern Naga People Organization has been in direct talks with the government of India, and they have demanded securing financial, legislative, executive autonomy. However, the recent talks bring about the concept of a frontier Nagaland territory, which gives them a third option by the centre, and the Eastern Naga People's Organization, which is in talks, is saying that it will consider it. However, it's not going backward on the autonomy for financial, executive and legislative. They have been demanding a separate state of Nagaland, especially within a separate state of Nagaland, and the centre has made an arrangement for a frontier Naga territory within the state of Nagaland with more autonomy. Now, there has been a long-standing demand for a separate state of Eastern Nagaland, primarily driven by the backwardness of this region, and this has flared up during the 2023 Assembly elections as well. There have been multiple rounds of talks. Let me tell you that the current talks come after a pause of after a year, which there has been a wait for the Nagaland government to come forward with its comments on the centre's draft memorandum of settlement on arrangement. And now the last issue is about the center and the Ladakh leaders discussing a new land policy. Let me tell you that the Ladakh has been separated from Jammu and Kashmir as a union territory in 2019, and the plan, they have three demands. They want statehood with their own legislative assembly. They want more number of MPs, and also they want 6th schedule status as well. So the Ladakhis are seeking higher cutoff for domicile status for outsiders seeking government job as well. The Ministry of Home Affairs is considering a proposal to regularize this is the newest development in Ladakh issue. So it is considering regularizing vast areas of government land in the Union Territory of Ladakh in the names of local residents who have been using or tending these barren or wastelands over the years. The proposal was discussed at a high-level committee meeting between the Ladakhi civil society leaders and the Ministry of Home Affairs. The practice of cultivating wasteland now is called as Notter, and it has its origin during 1932 by Hari Singh, the erstwhile king of Jammu and Kashmir. Himachal Pradesh has also had a Notter land policy since 1968. Through its implementation, though its implementation has now been halted by the government of the state. And Ladakh comprises Kargil and Leh divisions, and protests have erupted since 2019 demanding for special status or demanding statehood for Ladakh and also 6th schedule status as well. So this Notter regularization in the names of the holders of Ladakhis is being described as a revolutionary step by the locals of Ladakh. Especially they say that the fear of outsiders taking over their resources in the fragile region is amongst the biggest concerns of these people, and this is definitely going to subside. According to a public information, the Leh district has 14,400 acres of Notter land. The information for Kargil is not available, let me tell you. And as I told you, the high-powered committee led by Union Minister of State and of Home, Nityananda Rai, was first constituted in 23 January to address concerns of the people of Ladakh. However, the talks broke down in March 2024. In October 2024, we had seen Sonam Wangchuk, an environmentalist who had taken up an indefinite fast in Delhi to draw the government's attention to Ladakhi's demand, after which the Ministry of Home Affairs agreed to resume talks with the civil society leaders. And recent development is regularization of this wasteland in the name of the Ladakhis to remove the fear of taking away from the outsiders. So this is about the issue, and the last issue is that Supreme Court has given a notice to the Election Commission now on the rule change with regard to elections. So the Law Ministry had amended the Conduct of Election Rules 1961 last month, which would effectively exclude CCTV and electronic footage of the poll process from the public scrutiny. The Election Commission of India now a notice on the Election Commission of India rule has now been filed by the opposition Congress leader, challenging the amendment to the Conduct of Election rules, saying that limiting the public scrutiny will only lead to a backdrop on accountability and transparency, limiting transparency and accountability in elections. So what exactly will be the effect of this? Let's discuss in the next post when I deal with polity and governance for the week gone by. And these are the important topics that we need to remember and keep track of for polity and governance. If you did, please do like, share and subscribe, and don't forget to comment at the end of the video. I shall see you in my next post. Until then, it's very happy learning.